Thank you to everybody for joining this afternoon. We are going to be talking today about employment contracts, do's and don'ts, with a particular focus on California, because as we all know, it can be the most difficult state in terms of compliance and also fraught with litigation risks. So there have been numerous developments over the course of the last couple of years relating to contracting in the employment arena. And we thought we would bring you, as part of the Deal or No Deal presentation, some tips on areas where you might want to improve on your employment contracts. Before we launch into the presentation today, I'd like to introduce all of our speakers. And yes, this is the same glamour, the same people that you see here in these glamour shots, although we might look a little bit different and untouched. But I'm Barbara Antonucci. I've been practicing, employment defense for the last 20 years. I particularly focus on both employment counseling and run the gamut of almost every area of employment counseling, as well as employment litigation, both single plaintiff and wage and hour.
Hi, I'm Sarah Robertson. I've been practicing for 31 years this year, and I have pretty much the same practice areas that Barbara has. I do employment litigation, but I also do a lot of advice work for in-house counsel and HR managers on compliance issues and things like what we're talking about today.
Good afternoon. I'm Sarah Hamilton, also out of the San Francisco office. I have been practicing for 15 years, and I have a broad practice, wage and hour compliance, litigation, single plaintiff cases, and counseling along the lines of what we're talking about today. I also do some traditional labor work. Welcome.
Hi, good afternoon. My name is Jasmine Anderson. I've been practicing for about 13 years. I'm a senior counsel in the San Francisco office, and my practice focuses primarily on single plaintiff litigation and advice and counseling.
Thanks, everybody. Well, let's get right to it. Our presentation today is going to cover some areas of employment contracting. We obviously cannot cover every possible area, so we're going to focus on three primary areas today. One is offer letters. Many believe that an offer letter cannot create contractual obligations, but we have found that they often do. So we're going to be talking to you about what to include and what not to include in an offer letter today. We will also be addressing generally updates in California to arbitration agreements. Again, we could probably spend hours, even days, talking about all of the possible laws that impact arbitration agreements, but we're going to focus on some recent updates in this area that you should be aware of, and look critically at your agreements if you do have them with those updates in mind. Lastly, we're going to focus on separation agreements. Many of you, I'm sure, will be utilizing separation agreements when there is a risk, when there's not a risk, when, it's just part of a typical severance plan. And we're going to be updating you on a couple of areas to watch out for in that, on that subject as well. What we won't be getting into today, which are all of which are critical areas in the under the topic of employment contracting, we won't be getting into executive compensation agreements. We'll really be focusing on your at-will employment agreements today. And we won't be talking about proprietary information and confidentiality agreements, also a subject we are quite familiar with, but probably too lengthy to address today. And we will not be talking about commission agreements or stock option agreements, but you should all be aware that those are obviously agreements that relate to the employment relationship. for which you should seek counsel if you are developing plans in those areas or rolling out agreements in those areas. But we won't be touching on those today because we just simply don't have enough time, but we're happy to provide any advice should you reach out to us. So offer letters, this is a topic I'll be covering today. And I wanted to just walk through very generally, because I get this question all the time, what should be and what should not be in an offer letter. I think there are probably roughly 7 critical topics or things that I look for when I'm reviewing offer letters on behalf of my clients. You know, some very easy, and I find in most letters, and others that I don't see or I see addressed incorrectly and can cause to some can lead to some serious risk in this particular area. So as I mentioned, we're going to be talking about at-will agreements. So what I like to see in an offer letter, in addition to what most of you probably put in, is that, you know, we're offering, you know, you to employment in this particular position or title. Is I like to see a statement in an offer letter that reinforces that this is an at-will employment relationship. That means that you, of course, can terminate the relationship at any time with or without cause or advance notice, and change the terms and conditions of employment with or without cause or advanced notice. That's important because, as I said, many times what we will see is litigation over promises that were made in an offer letter, separate and apart from agreements that you would typically consider contractual. You know, by building in this at-will language, you are essentially advising employees or prospective employees that they are not, you know, that you are not creating a contract by virtue of this offer. Now, of course, if you have an executive contract, you know, you'll typically have some just cause provisions, or at least you know, it could include something like an obligation to pay severance if someone is terminated without just cause. So you won't see that in a typical at-will employee offer letter. And you likely should not include at-will language if there is a separate executive contract to the contrary. And another area or group of employees to watch out for when you're including at-will language in your offer letter is unionized employees. Typically, if you have a union employee, there are some cause provisions in collective bargaining agreements that might relate to their terminations and their conditions of employment. So again, be careful when utilizing at-will language with respect to those two types of employees. What the question I often get is number 3 on this list, whether or not you should state in an offer letter that the employee is exempt from overtime requirements or non-exempt from overtime requirements. You know, whether or not you state it is not, it's just not something that is required. But it's certainly going to be something that informs your decision as to whether you set in the offer letter, number 4, an hourly rate or a salary. And that is something that you should set forth in your offer letters, is an hourly rate or a salary. You know, how will the person be compensated? What I also see, in addition to just, you know, you will be compensated at a rate of $15 per hour, or you will be compensated, you know, at a salary of X, which will be paid bi-weekly or weekly, you know, in accordance with our regular payroll process, is I see reference to a number of different things, such as commissions, bonuses, such as signing bonuses, you know, or even just yearly bonuses, performance bonuses. And, you know, or I often see other types of compensation addressed, such as stock. Now, one, caveat here important to you all as you are reviewing your offer letters is when addressing these other issues such as bonuses, commissions, and stock, anything beyond just, what the hourly or the salary rate is, it is critical to refer back or contain language in your offer letter that says in accordance with the terms of those plans, whether that be a bonus plan, a commission plan, or stock plan. And the reason is you don't want your offer letter to create an obligation separate and apart from the terms and conditions of those plans. And so by referring back to those plans and incorporating them, you are protecting yourselves that you're, from future contractual claims, separate from those plans, which I'm sure you have thoroughly thought through the language of, but may not have, or may be attempting to summarize in the offer letter itself. So that another issue similar to the compensation issues as to commissions, bonuses, and stock that I see in offer letters is I often see reference to benefits, whether they be health benefits, 401k benefits, vacation, PTO, which are not technically benefits, but certainly a benefit that you provide to your employees. When referencing these to different benefits, which is very common and we can absolutely do in your offer letter, we tend to see, once again, an absence of language tying it to the actual plan itself. And we like to do that again to avoid creating disparate contractual obligations. So another issue to watch out for. No, point 6, many times we will include language in an offer letter that says that your employment is contingent upon a number of different things, whether they be background checks, drug tests, the eligibility to work in the United States, all very important things to reference. However, if the offer is truly contingent upon those things, however, we do want to just highlight that the offer letter is really not the place to address those issues in their entirety or thoroughly. And you will need additional documents and contracts to address those issues. And so if you do include, for example, your offer will be contingent upon a background check, satisfactorily completing a background check. There are laws, both federal and in California and other states, that require particular disclosures and authorizations in order to conduct those checks. And simply an offhanded reference in an offer letter is not sufficient typically to meet those obligations. So you'll want to refer and make sure that you have those separate forms available in order to in order to administer those processes. Same thing goes for drug tests. If you're going to say in an offer letter that the employment is contingent upon satisfactorily passing a drug test, we better make sure that your policies and practices are compliant with with the multiple state and federal laws in this area. Random tests versus pre-employment tests versus, post-accident tests are all, very different and treated very differently in the law. And so to the extent you are going to say, that your offer is contingent on a drug test, we strongly advise you to have a good, compliant drug testing policy and process in place alongside it. With respect to other documents, we often see, within the offer letter itself, a reference to we acknowledging compliance with an employee handbook, or acknowledging receipt and compliance with a proprietary information agreement. And sometimes we even see freestanding obligations to arbitrate claims in those offer letters. Once again, while we can make reference to those things in the offer letter, we suggest that there be separate freestanding agreements for all of these various topics. With that, I'm going to turn it over to Sarah Hamilton to address the topic of arbitration agreements.
Great. Good afternoon, everyone. The topic of arbitration agreements is one that I would say over the course of my career has been really a shift in terms of do we do it, do we not, and what is our advice in this space. I would say at the outset of my work in this space, we would really debate the pros and cons. There were probably fewer pros, and it was really more of a question mark for employers in California whether to enact an arbitration agreement. Over time, I would say we've seen a real uptick in terms of why an employer may want to do so. Probably the main leading charge in terms of pros is the laws that are developed with respect to class action waivers. And so with the courts supporting the idea that you can add a provision into your arbitration agreement that would force an individual to go into a single plaintiff arbitration and leave their class action behind, many employers have taken this to heart and put these arbitration agreements into place. Obviously, there's a real upside if you're litigating against one employee versus the scope of a large scale class action, especially here in California. The other, kind of pros for having arbitration agreements, typically it's faster. That allows parties to manage especially their attorney's fees, because we're on a shorter timeline. I would say, certainly in the COVID era, this may be, really of high interest to employers as they're looking at dockets getting really backlogged. I was just in court a few weeks ago, and they're saying that they're at least 9 months behind on their docket. While I've got arbitrations that are being set, for April right now, May, June, easily with a private arbitrator. Arbitrator versus jury, this can go a little bit of both ways, but I think, on balance in California and certainly where we're resident in the Bay Area, I would say, if you can have a less emotion-fueled jury and get to kind of the heart of the matter with a neutral arbitrator for many employment claims, that would be a preference to the company. Finality, you don't have, endless layers of appeals to deal with. Typically there's, agreement that you guys will be bound by the decision. It's less formal and streamlined, which means we often can, get away with all of the extraneous extensive discovery that we have in California in particular, form interrogatories. Otherwise, arbitrators help the parties really get to the heart of the matter, get the exchange done, and frankly, get to that hearing without a lot of the procedural garbage that we often see when we're litigating, years in court. The certainty of a hearing date, the parties sit there, work through the date, get it penned down with the arbitrator. You have control over that date, through the parties and the arbitrator to get a schedule that works for everybody. Again, less discovery goes back to the streamlined process. And for many employers, just the fact that it's not a public outing of the situation, it's confidential. It's, oftentimes under the guise of just a private arbitration and not, public forum where anybody can have access to it on a public court docket. While there's, many pros, and I think, like I said, I would say the pros at this point, especially with the class action waiver, outweigh the negatives. There is a cost. It costs money to go to arbitration. You're paying for a private arbitrator. I think some would say that sometimes having an arbitrator as the decision maker, where there's, potential repeat business or otherwise by the plaintiff's counsel employer or defense counsel, that sometimes there'll be a tendency to split the baby, come up with that middle result. I think the cost for smaller matters, it can become just really more costly. But certainly on the big picture, I think many employers with the class action waiver benefit alone will push towards arbitration. that said, and I'll talk about it a little bit more in a few minutes. What we don't have is the ability to push our California Private Attorney General Act claims, the PAGA claims, into arbitration right now. So while you can force an individual or a class action into an individual arbitration, get rid of your class action, we get left with this, plaintiffs counsel driven, broad PAGA representative case, still kind of out there for everyone to litigate on the back end. So you don't have total piece of these bigger cases anymore. And the laws, developed not favorably in that space. And so that, that's a balance point. Barbara, you want to take to the next slide?
Yes.
So I guess my biggest premise with arbitration agreements is if you're going to roll one out, you have to roll it out, revisit it, because the law is consistently and constantly changing. What's required today is likely not the same requirements that we'll see 3 months from now, 6 months from now, otherwise. And certainly it's a lot of work for your teams to roll out arbitration agreements and come up with a program for getting these out to your employees. But if you're going to do it, you can't roll it out and sit back and just, I guess you could sit back and cross your fingers, but more likely than not, your arbitration agreement is going to need updating pretty regularly, at least in terms of an audit process, reviewing what's out there and watching the changes in the law. It changes, I kid you not, by the month in terms of what are our best practices. So put into schedule an audit process on your arbitration agreement. Certainly, we're in prime season for reviewing policies and handbooks, and frankly, your new hire packets. Arbitration agreements need to be right there in the mix. So just in the last year or so, we've had a couple areas of legal developments, probably to most significantly note. Some still moving targets for us to keep an eye on. Probably one of the most pressing ones was AB 51, which was last fall and went into effect in January 1st, 2020. AB 51 basically said that mandatory arbitration agreements are prohibited. So you can't force an employee to sign it, can't force them as a condition of their employment. And frankly, even allowing for the employee to opt out is not sufficient to be voluntary. So you need to make it, really a voluntary agreement. AB 51 doesn't come without a lot of baggage in terms of does it apply and how does this actually work. The statute has a carve out for arbitration agreements subject to the FAA, such that they may still be enforced. But it appears that some of the penalties and otherwise of such agreements may still have impact. So, many, probably most of you listening in on this presentation would have a business that if you employed an arbitration agreement would be subject to the FAA. Your business is engaged in some sort of interstate commerce. And so many of you will be under this carve out, which again left some unanswered questions. Well, fast forward into the early parts of 2020, and there was quite a bit of litigation with respect to FAA preemption arguments and seeking to enjoin application of this whole provision with respect to those agreements. We do not have, the settled answer or law. Otherwise, we're expecting oral argument probably by the end of this year and some further guidance. The current status quo, if you're subject to the FAA, is that your agreements, are likely okay. But I think, to the extent you are in that space, you should be thinking, looking, coming up with what is your plan and how does that look? And certainly if you're not within the FAA, as in your business really is California centric, those are the most clear examples. Take a look at your agreements, make sure that you're not forcing the mandatory provisions, that you've got an agreement that you feel like will do all the things that you want it to do. Another development, and this seemed a little more exciting at the time, there was a case called Otto versus Co., which said that California Labor Commissioner hearings could not be, explicitly pushed into arbitration under the arbitration agreement. So this would be like your labor code charges that you sometimes get with employees, the administrative hearings. The case basically came down on a couple different areas in terms of how that arbitration agreement got rolled out. On the back end, many employers are deciding just to take out forcing labor code provision or labor commissioner charges into arbitration, because frankly, to do so would have been, it's often difficult for the employer anyhow. So they're just carving them out altogether. But if you are going to want to do that, it's something you need to look at, because the issue in that case was that it was just too procedurally difficult on the employee, too burdensome, too expensive to send them into arbitration when they were looking for a quick administrative hearing. So the procedures were just really not aligned with what it would have been to go to a commissioner hearing. So take a look, see if you have one of those in your arbitration agreements. If you had previously been forcing them into arbitration or had the ability to, you're going to want to take a look at your language and likely carve it out. PAGA claims, as I mentioned before, this is probably the biggest thorn in an employment lawyer side, are not subject to arbitration agreements. That means what happens many times is you'll get maybe a class action with this PAGA claim sitting alongside it. You'll successfully, as the employer, compel the individual to an individual arbitration where they have to drop their class claim, and you're patting yourself on the back, which is great, except after the arbitration, you'll get sent back to court at some point to litigate the PAGA representative claim. It's a 1-year claim with penalties associated. Certainly, if you litigate an arbitration and you get a bad result, that kind of frames what you're going to look like in a PAGA representative action. So it creates a lot of, noise when you're litigating it, especially in these wage hour claims that we see in California.
Sarah, I think you covered these slides, so I'm going to jump us right to our next question, which is, can we do any of the carve outs? Can we have in an arbitration agreement any carve outs? And that has been a question that has been recently litigated, and litigated also not so recently. In fact, as early as Armendariz, which was a California Supreme Court decision, where the court looked into whether an agreement that required the employee to arbitrate wrongful termination claims, but did not require the employer to arbitrate similar claims, was, enforceable. And the court looked into, obviously, terminology that you all may have heard before: unconscionability, substantive and procedural. But the main focus of the decision was really on this concept of mutuality, and whether or not you could have provisions in an arbitration agreement that were both that applied to the employee but not the employer, and vice versa. And the court ultimately found, that the agreement was problematic because an employee was going to be required to bring their wrongful termination claim in court. In arbitration, while the employer could bring the same issue that, with respect to the employee having violated perhaps a trade secret claim, a trade secret provision in his confidentiality agreement, and the termination that resulted from that in court. And the court found that just simply wasn't mutual, simply, not fair. So it brings us to, the question of what is it that we can and cannot carve out of arbitration agreements in California. And our advice on this would be, you want to include mutuality language in the agreement. So you want to say that it is not only the employee, but the employer that is bound by the agreement to arbitrate claims related to employment. You can carve out, injunctive relief relating to certain, actions to enforce trade secret violations and other, confidentiality provisions. So you can carve out being able to bring injunctive relief in court. But, to carve out specifically that the employer can bring proprietary information claims in court for damages might be problematic. So we do see often contradictory contracts, both in the proprietary information agreement and in the arbitration agreement, that may conflict on this issue. So that's certainly something to look out for. Another recent trend in the arbitration arena has been, can you carve out harassment and discrimination claims? Some of you may have seen post-Weinstein, many companies such as Uber announcing, that they were going to, when it comes to issues of sexual assault and sexual harassment, carve out such claims from their arbitration agreements or provisions or mandatory arbitration programs. The idea being, if both parties are able to bring those claims in court, and both parties are able to bring those claims in arbitration, you certainly can, we believe, have a carve out, although it seems to run a bit afoul of the mutuality standards that were set forth in Armendariz. One last piece on arbitrations before I turn it over to Sarah and Robertson and Jasmine to talk about separation agreements is, in January of this year, there is a new law in California that essentially states that you have to cover, you have to pay fees and costs associated, or the employer, the drafting party, often the employer, has to pay the costs and fees associated with arbitration within 30 days of the due date. And that statute applies to the initial filing fees as well as the fees throughout the arbitration. Very important. We often see in an arbitration agreement that complies with Armendariz the obligation that the employer will cover any fees above and beyond the fees that would normally be associated with court filings. Now, just a really important point that, you want to be really careful to make sure to pay those fees on time, because not doing so might lead you to actually waive your right to arbitration. And in fact, it says so right in the statute. Sarah? My apologies. One last slide for me. We do often see choice of law provisions in the arbitration agreements as well. Really important to note, although it's been on the books for a couple years now, but we still see it in old agreements. You cannot have a choice of law provision outside of California, or a choice of venue provision outside of California, if the employee primarily resides and works in California.
Okay, so we're also going to talk about separation agreements. They could be the ERISA kind, where you have a separation or a severance agreement that is an actual severance plan, or it could be what we think are the more typical kind of, I call it a separation agreement to make the distinction, those agreements that you offer to people at the time of termination, just to try to buy peace and see if you can get them to go away without any kind of a dispute. So we're going to talk about some of the new laws in California that have to do with no rehire provisions, confidentiality, and non-disparagement. So starting with the no rehire provision, there has been a bit of press about this, but in case you missed it, as of January 1 of 2020, there's a new Code of Civil Procedure section in California that bans provisions that would prohibit people from coming back to work for you in an agreement to settle an employment dispute. So obviously, if you're talking about settling in a lawsuit that's already underway, that's the main thing that this would apply to. But you do have to pause when you're thinking about kind of a garden variety separation agreement and ask yourself, might this apply here? I mean, we've all been using these forever to try to tamp down the risk of retaliation claims by people who leave the employ of the company, and certainly in a settlement agreement, we're almost always using a no rehire provision, and sometimes people will have them in their standard separation agreement that they give to people at termination. So, Barbara, if you could go to the next slide, this is the real question here about whether this new law could apply to a normal separation agreement. So the new law says that it only applies to a quote unquote aggrieved person. That's the only category of employee who's impacted by this new law. And so an aggrieved person is somebody who's filed a lawsuit in court. Well, that's obvious. Filed a claim with an agency like the Department of Fair Employment and Housing or the EEOC, or filed a complaint through the employer's internal complaint process. So if you can go to the next slide, Barbara. So you can imagine the situation here that you're doing a severance agreement with somebody who has a pending internal HR complaint. It could be construed, and I think would be under this new law, that you are settling an employment dispute. And if that's the case, you can't have no rehire language in there. There is an exception that if you had the example I just described, where you've got somebody who's presented a DFEH complaint or complained internally, you can have a no rehire provision if that person who you're making the agreement with engaged in sexual harassment or sexual assault. So in other words, if you're doing a separation agreement with the quote unquote harasser, and you've done an individual or an independent investigation and found them to have violated your harassment policies, then you can put a no rehire. Similarly, the prohibition doesn't require you to employ or obviously employ, but rehire being the important part, a person if there's a legitimate non-discriminatory and non-retaliatory reason that you terminated the employee. So, you're doing a separation agreement with someone where you have super cause, you know, they embezzled from you, whatever it might be. You think you've definitely got that cause. You could put a no rehire provision in there, but you may have to litigate whether it fits this exception or not. So that's the thing that you'll want to think about is, are we so, in terms of balancing the risks, are we ready to take the risk that this person wants to litigate over the question of whether they fit that category? If you think your facts are fantastic, maybe it's not much risk at all. But if you've got one of these kind of iffy situations where the person has just had sort of substandard performance and not great reviews, and you're going to tell them that you're just decided to end the employment because it's not a fit, and then you put the no rehire provision, and they may try to come back and challenge it and say you didn't have this kind of a reason to let me go. So, and again, assuming that they were already in some kind of a dispute with you.
Sarah,
So,
what would be the benefit of a no rehire provision? We had that one of those questions come from the
oh,
audience.
sure. So the benefit of a no rehire provision in general is that a lot of times if you're separating with somebody who you really don't want to see again at your company, or if they've already made a discrimination complaint or something like that, if they leave and they sign a settlement, well, whether they sign a settlement agreement or not, if they leave and you don't have a no rehire provision with them, they could then seek to come back. I've seen it happen with a couple of clients. They could seek to be rehired by you. And when you don't hire them, they'll say, well, the only reason you didn't hire me is because when I worked for you before, I had a race discrimination complaint or a sexual harassment complaint. So you're retaliating against me by not bringing me back because I engaged in protected activity when I worked for you the last time. So especially when people are settling lawsuits, they frequently like to include that because of course the employee has already gone all the way into a lawsuit. And so they were trying to protect their right to be free of discrimination. They would say, so, you know, why don't you, the reason you don't bring me back is because of my lawsuit. So there is a trend that we've seen with some of our clients where they're trying to avail themselves of that language that says if you terminated somebody for a legitimate non-discriminatory reason, then this prohibition on the rehire clause doesn't apply. And so people are trying to put language in their agreements that says, we all agree in advance that our reason the reasons that are in the personnel file for the termination of this employment are sufficient for us to deny reemployment in the future. You could do it if you want, but I don't like it, because I think what's going to happen is the employer who puts this kind of language in may be the test case for whether this is a good way to avoid the implication or the application of this new law. And so, you know, if you have the fortitude and the budget to be the test case and you feel strongly about it, more power to you. But I think if you unless you want to fight that first battle on this, I think that the safer way to go would be just not to put a no rehire provision in that agreement at all. And then if the person reapplies, be sure you select someone who's obviously more qualified and just be prepared to defend the retaliation claim there. Because I think you'll still get the retaliation claim if you use this language, and they'll seek to void the carve out that you tried to do under the new law. And I don't know, it seems to me like it's buying trouble, but you all can decide for yourselves. We just want to let you know some folks are trying to do that. So I think the main takeaways here are to update your separation agreements to make sure that they comply with the current law in California, and to make sure you have a no rehire provision. Well, if you want to have a no rehire provision in a standard separation agreement that just, you know, says you'll never come back to us, then make sure the people who are using that agreement are aware that if the employee has already brought forth an internal complaint, that they probably can't use that no rehire provision and that they should talk to you in legal. And then if you have, but just to make sure we're not losing the forest for the trees, if you have employees who are separating and you're handing them this agreement on their last day, and they don't have any complaint, this is just somebody that you've worked with for a while who has to go because of the downturn in the economy or for whatever reason, and there hasn't been any complaint, you can have a no rehire provision if you want one. So, so I think, again, just making sure that you've got your contracts checked by California Council is important right now. There've been a lot of changes, and Jasmine's about to tell you about another one.
All right, thank you, Sarah. Last but certainly not least. So there have been many changes to the types of things we can put in separation or severance agreements. And a lot of those changes were fueled by the Me Too movement. In particular, in 2018, California passed several different laws in response to the Me Too movement. One of those new laws is known as the STAND Act, which literally stands for Stand Together Against Non-Disclosure. Several different trending topics led to the creation of the STAND Act, and I'll just throw 3 names out there to give a prime example: Harvey Weinstein, Larry Nassar, and Bill Cosby. So before the STAND Act was created, there were a lot of trending topics talking about how victims of alleged harassers felt that they could not share their stories and come together in solidarity because they were bound by these very strict, very limiting non-disclosures agreements. So California was one of the leading states to kind of take a public policy approach to non-disclosure agreements and say, hey, from that type of public policy perspective, these non-disclosure agreements are not right, and we need to do something about it. So that led us to what's now been codified as California Code of Procedure Section 1001. And what that section prevents is for settlement agreements that are entered into after January 1st, 2019, confidentiality provisions are prohibited in settlement agreements that settle claims for sexual assault, sexual harassment, workplace sex harassment or sex discrimination, failure to prevent these type of claims or this type of conduct, or retaliation for making a report of sexual harassment or sexual discrimination. Although it prohibits, the section prohibits confidentiality with respect to these issues, the STAND Act does allow for the victim's identity to be confidential. So it really puts the power in the victim's hands to be able to share their story, but at the same time, be able to keep their identity protected from public disclosure. Now, the STAND Act applies to civil lawsuits that are filed in court or an administrative action that's filed with an administrative agency, such as the Equal Employment Opportunity Commission, which is the federal agency that investigates these type of claims for harassment or discrimination, or the DFEH, which is California's Department of Fair Employment and Housing. That's the state equivalent to the EEOC that investigates these type of claims in violation of California law. Next slide, Barbara. Oh, you're already there. Thank you. No problem. Nope, you're good. Thank you. So we get a lot of questions about the reach of the STAND Act. So how far do we have to go with limiting non-disclosure agreements? Our clients often wonder, well, if we're offering a separation package to an employee to end the employment relationship, and this employee has complained about sex harassment or sex discrimination in the past, can we have a confidentiality in the separation agreement? So fortunately, in most cases, the answer is yes, because there's no lawsuit or administrative action filed. So CCP section 1001 really only applies to post litigation settlements. So if there's a lawsuit filed in court, if there's an administrative action filed with one of those agencies, then this particular code section comes into play. If we're talking about a pre-litigation separation agreement, which more often than not, a separation agreement is going to be before there's any litigation filed, then fortunately you don't have to worry about the issues with having a confidentiality provision in your separation agreement. But you do have to be careful. So let's assume for a second that a current employee filed a complaint of sexual harassment with the EEOC while they're still employed there. Sometimes an employer is going to want to negotiate a separation agreement with that employee, and in exchange for typically monetary compensation, they'll ask the employee to dismiss their EEOC or their DFEH charge. So under those circumstances, if you're dealing with a current employee who may have a pending action at that time, since the separation agreement would serve as a settlement for the EEOC charge, for example, a confidentiality provision may not be permissible. So just to reiterate, if you're dealing with a situation where you're separating an employee who doesn't have a pending action on file at the time, you probably don't have to worry about the NDA issues. If the employee does have a pending action on file at the time of the separation, then you're likely going to want to talk to and seek advice and counsel about how to handle the non-disclosure issues. A couple of other points to keep in mind is that in a settlement agreement where a confidentiality provision is prohibited, it is possible to maintain confidentiality of issues not related to sexual assault, sexual harassment, or sex discrimination. So oftentimes our clients will want to maintain as much confidentiality as possible. So we'll draft different carve-out language that says, okay, you're free to talk about the sexual harassment, the sex discrimination issues, but if you had an issue with your boss over a disability discrimination or failure to accommodate a disability, we can keep that stuff in-house and we can keep that stuff confidential. So that's something to think about when you're looking at whether a carve out for various things makes sense with respect to non-disclosure. Another question we often get is whether if you are settling a claim for sexual harassment, discrimination, or related retaliation, can you keep the settlement amount confidential? Oftentimes our clients do not want the settlement amount to be disclosed to the public, because then it sets a floor for the next sexual harassment claim that they might get down the line. So the fortunate thing is that, yes, the settlement amount can be kept confidential. And we have provided some language, it was on the prior slide, but we provided some language that you can use in a separation agreement or a settlement agreement to ensure that the settlement amount stays confidential. So with respect to non-disparagement clauses, again, another product of the Me Too movement is SB 1300, which was codified into Government Code Section 12964.5. And that Government Code section refers to California's Fair Employment and Housing Act, which are the state laws prohibiting harassment and discrimination. So SB 1300 makes it unlawful for unlawful employment practice for an employer to, in exchange for a raise, bonus, or as a condition of employment, to either require an employee to sign a non-disparagement agreement or require the employee to sign a release that they do not have any claim or injury against the employer, and release those rights. However, the prohibition against non-disparagement clauses does not apply to a negotiated settlement agreement to resolve a claim in court or before administrative agency. So again, if you're talking about typical run-of-the-mill in court settling a case, this law is not going to come in play. What it's really looking to prevent, you can turn to the next slide, Barbara. What this particular new law is really aimed at are offer letters and having non-disparagement clauses in an offer letter or as an incentive for the employee to stay until the separation date. So, for example, a lot of times, as Barbara mentioned, with offer letters, there's often a confidentiality agreement or a proprietary inventions agreement that's kind of coupled with confidentiality that comes with the offer letter. So what this new law is trying to aim at is that there cannot be a condition of non-disparagement in exchange for that offer letter or for continued employment. We're also seeing a somewhat of a new trend of where this issue is coming up in separation agreements. And how it's come up in separation agreements is that, let's say you have an employee who you're ending the employment relationship. You've decided that on X date, let's say October 29th, they're no longer going to perform services for you, but their actual termination date may be somewhere in the future. So let's say their actual termination date will be 2 weeks from now on November 16th. So, and sometimes that happens because certain benefits that the employee may receive, such as vesting of stock or so forth, requires them to be there for a certain time. So even though you may no longer want that employee performing services for you, to be kind, you might let them stay through whatever their vesting date is so that they get their stock options or whatever their bonus may be. So we found one case that said doing that, so having an employee stop performing services you for one at an earlier date and then actually ending their termination at a later date can be considered continued employment. So in this particular case, the court found that the non-disparagement clauses in the separation agreement were invalid simply for that reason, simply because there was a stopping work date that was different from the actual termination date. So it's important to think about these things as you're making these various decisions within your organizations. We all know that and even experienced ourselves kind of the impact that COVID-19 has had on our clients and on employers. So we know these things are hot topic items right now. And so it's really important to kind of think through those things and how do you go about making sure that your separation agreement is going to be legally compliant. In this particular example, with this one case, what the employer probably should have done was either had one just solid separation date, so just moved it out to whatever date that employee's stocks would have vested, and then that way there wouldn't have been an argument of continued employment. Or if they wanted to have the two different dates, have either a second agreement or an addendum to the first agreement, so that it would be clear that there was no continued employment in the employment relationship severed at that later date. There's another point that I wanted to make that's not on the slides. I know we only have 1 minute left, but with respect to non-disparagement clauses, it's also important to consider about whether an employee can seek relief from administrative agency like the EEOC. A few years ago, the EEOC was very hot to trot on non-disparagement clauses that prohibited or discourage employees from being able to go to the EEOC and make complaints. So that's something that you also want to think about as well. And with that, we've hit time.
Thanks, Jasmine. I know we are scheduled to end here at 2:30. To the extent that anybody would like to stay and lodge questions in the chat, we will be here. There are a couple of questions which I'm happy to address that have been raised already. For those of you that would like to continue on, we will be here to address them. So I'll take the first one. The first question that was raised was whether or not the payroll dates of the company need to be in the offer letter. And that's a really interesting question because California law has a labor code section 2810.5, also kindly known as the Wage Theft Act, that requires you to provide notice to non-exempt employees of a variety of different things, including things such as the rate of pay, the regular pay date, the overtime rate, workers' compensation, how sick leave is provided, and a number of other things. Typically, what I've seen is employers will do that in a form called the Wage Theft Act form or Labor Code 2810.5 form. So not sure whether it really has to be in the offer letter, but you do have to provide that notice. So hopefully that wraps it up. We have about 3 minutes until the next session in the same Zoom room. So I wanted to address one very important question that was raised about an executive, and isn't an executive in fact at will, even though they may have a term of employment set forth in their executive contract, or they may have some compensation, such as severance, that triggers upon termination if someone is terminated without cause. And that's absolutely true. Yes. I mean, all the more important, and I hope I wasn't misleading in this respect, all the more important to contain at-will language in that employment contract, because such terms and such provisions could, in fact, potentially lead to an implied contract not to terminate without cause. So that at-will language is important to have. My apologies for not addressing that more clearly earlier. I don't see any other questions, but we are happy to take anything offline. You should have all of our contact information, and we really hope that you've enjoyed this brief entree into employment contracts, do's and don'ts, and enjoy the rest of your day.